Good afternoon and welcome. Today, thank you for joining us for our LGBTQ plus rights in schools, colleges, and universities. And I guess I'll put a little disclaimer out here right now that as we were preparing, we realized most all of our updates are specifically related to transgender students. So we'll kind of throw things in as they come up, but that is our primary focus today. I am Kendra Yoch, and I am joined by Jennifer Smith.
Hello.
And Nicki Bazer. Hi, everyone. So thank you for joining us today. We've got some really interesting updates. This is a topic that is in the news right now. I know it can be a little bit confusing. The things that are coming and going, there are state laws about transgender athletes. There is uproar about critical race theory, and sometimes people throw in transgender and LGBTQ issues with that. There are new interpretations of Title IX with the administration that seems to change back and forth. And so I think there's confusion, and we want to kind of just lay things out for you, make it as straightforward as possible. As we're coming back to a new school year and we're going to be in person, I think we're going to see a lot of these things come up that maybe were a little bit more quiet last year when a lot of students were remote. Once everybody's in person and we're doing all the activities and everything's going on, we're going to have these issues coming up again. So I think it's good to do a review and just be up to date on where we are, what's the current status of everything. So we're going to go through federal updates. There's some things happening with the new administration. And then we're going to take stock of where things are in Illinois. There aren't as many changes in Illinois, but it's good to know where we are because there are changes happening in other states. And I know you guys hear that in the news, and I think we need to know what's applicable to schools here, what you can kind of put over to the side, other parents may raise or students may raise, but is not going to be controlling for you. And then we have some court cases that will just kind of give you a little preview of, again, nothing that is directly impacting us here in Illinois, but you'll see kind of where things are bubbling and moving, and we can kind of read the tea leaves a little bit. So with that, I'll let Jennifer start us off talking about some of the federal issues that are going on.
Sure. Thanks, Kendra. So to get us started, wanted to talk a little bit about the nomination of Catherine Lehman for as Assistant Secretary for Civil Rights. She is someone that our firm has experience with from her tenure as in the same position, Assistant Secretary of Civil Rights during the latter years of the Obama administration. So she, in that role, made some high profile decisions. And basically she's the head of OCR is really what that title means as far as your interaction with her as educational entities. So where we saw her style, I think beyond substance, her style is significant for school districts because she took a very adversarial, I would say, approach, and I don't even know if she would disagree with that. She said at different times, for example, there's always been kind of speculation among school attorneys, how real is the threat that the Department of Education will cut your federal funding? Is that just a fairy tale that is told to scare schools but never actually happens? And she was very aggressive about making the point, basically, I will take your federal funds, I have taken federal funds, and I'm not afraid. I'm paraphrasing, but not that far. She was so aggressive. It's not like she was out in the public saying, we want to collaborate with schools and work together to find, mutually workable solutions. No, it was, this is the law. If you don't follow the way I tell you to follow the law, I'm coming after your federal funds. And I don't think she's apologetic about that. She's an advocate. The core of her career before working in government was she worked for the ACLU and then for a public interest law firm. So she's very advocate and complainant you know, that was her background and experience. So I don't think she would not apologize for not being an institutionalist or thinking, you know, let's gently reform or coax compliance or use carrots. That's really hasn't been her style. Although with experience, we all come around to different positions. So I'm just saying what we've seen from her in the past. She's remained in the public forefront in the public during the Trump administration. She was chair of the U.S. Commission on Civil Rights. And I know I follow her on Twitter during the last 4 years just to see, you know, I suspected that it wasn't the last that we heard of her in a relevant role for what we do. So I've watched her career even during the Trump years, and she's continued to make her opinions be known around enforcement. Probably the most controversial thing that you're seeing quoted does touch on I think LGBTQ issues, because we know that population is particularly vulnerable around sexual assault and sexual harassment. So she's very firm in her opinions and has been very blunt that the Trump administration's enforcement of Title IX was weak. She made a statement, the inflammatory statement that, or some would think it would be inflammatory, is that the Trump administration took us back to the bad old days when it was permissible to rape and harass students with impunity. She's really stood by that statement, and so that gives you a pretty clear sense. You don't have to wonder what she's thinking. So, you know, we're waiting to see. She's given testimony before her confirmation hearing before the Senate. She was questioned, largely focused around transgender issues, because it was under her guidance that the Obama administration issued the transgender LGBTQ guidance that talked about facility access. That was a major point of controversy during her tenure. And then also Title IX enforcement, and she confirmed she would be enforcing the law as it is until it's changed. So as far as the regulations, she would enforce those, she confirmed, until they're changed. But so we will see if she's confirmed, but that's a very major, that really will impact, I think, clients on the ground. Should you get an OCR complaint, they take a very different approach, or they did before when she was in leadership. Other federal updates, I think everyone's heard about the Bostock decision at this point. We recently, even this summer, got updated guidance from the Obama administration confirming what I don't think was a surprise to anyone, that they do apply or interpret Bostock as applicable to Title IX, meaning sexual orientation and gender identity would be protected under Title IX, as Bostock decided it was under Title VII. So
quick slip of the tongue, Jen, the Biden administration, right?
Biden, sorry, yes, yes. So those are the major recent developments that I wanted to highlight at the federal level.
Excellent. All right, and I'll just hit on one other one, which is the Equality Act, and that is supported by the administration, and it really amends the civil rights laws to specifically include sexual orientation and gender identity, so that it's not left to the court to decide, you know, does Title IX apply to this? Does Title VII apply? You know, what does sex mean if it's actually explicitly spelled out in the legislation? So that, I believe, has passed in the House. It has not yet been taken up in the Senate, but that's obviously something that the Biden administration is supporting, so that there would be this nationwide protection. It wouldn't be left state to state to figure out what the protections would be. And then it would go, you know, Bostock is specific to Title VII and employment. You know, this would be much broader. It would apply in education, in housing, in credit, and all sorts of things. So that's something that's out there to keep an eye on as well. And Nicki, you want to talk to us a little bit about some state issues?
Yeah, absolutely. And I'm going to start with Illinois and then shift to other states. But I do want to make the point at the outset that, Kendra sort of alluded to this at the beginning, which is we aren't seeing a huge amount of change in Illinois. And so I do want to reassure folks that we're sort of where we were before. If for another reason, then you don't have to implement a whole bunch of change, but we're seeing so much happening on the state level that we wanted to make clear what was not, impacting Illinois, where Illinois still was. And there's a lot of layers to Illinois. And of course, I'll try to hit on all of those. The first thing I'll just say in terms of Title IX compliance and federal law, we've had some decisions in terms of transgender students, particularly in the K-12 setting, access to things like restrooms and locker rooms. The federal circuit, Seventh Circuit that governs Illinois has consistently upheld those rights, and we don't anticipate any changes, particularly now that we're getting different federal guidance that's more consistent with where the Seventh Circuit has landed. So folks in Illinois, you're still governed by the decisions in the federal courts.
One thing I would just emphasize on that point, Nicki, is while we haven't seen a change at all, I think we haven't seen a great deal of enforcement in the last 4 years or during the Trump administration, because students did have to take the step, or families, that is different in that they'd have to actually file you could file a complaint with IDHR or file a lawsuit. Filing an OCR complaint is easy. And sometimes I find, families, students will shoot them off without a great deal of thought. You don't have to hire an attorney. You can kind of be sucked down a website and think, oh, I should do this. That's much different than, navigating or even finding the IDHR, or getting an attorney and filing a lawsuit or filing a pro se lawsuit. So although the law hasn't changed, I think some of us are a little dusty, or, it hasn't come to the forefront as much on enforcement. I expect we'll see aggressive enforcement from OCR starting really immediately with students back in school.
Yeah, I think that's a great point, Jen. And I think it's a great time. And we'll talk about sort of the other, obviously the state law that controls here. Jen references the Illinois Human Rights Act, and enforced by the Department of Human Rights in Illinois. And they've also come out with decisions upholding the rights of transgender students in schools. Again, we're seeing a lot of those at the K-12 level in particular. But I think it's a great time because obviously IDHR, the Illinois side, has not changed its position. It's a little bit more of a complicated process, as Jen alludes to, than OCR. We are expecting to see OCR ramp up its enforcement. I think it's a great time to take a look at your educational policies, your internal school, whether you have a policy, you have a procedure, you have informal guidance to your staff, and make sure it is supportive of students who are transgender, that it's in keeping with the guidance that we're seeing on both the state and federal levels, and that you are looking at all aspects. And, we're certainly happy to help to walk you through. I've done a lot of reviews and policy drafting, and just thinking through all of the issues that students, everything obviously from bullying issues, to sort of the nuts and bolts of how they make their way through the school day. So absolutely things to think about. I just mentioned bullying, and obviously Illinois has always had, not always had, but for a number of years now has had a very robust K-12 anti-bullying law, which does protect folks based on sexual orientation and gender identity. And so obviously that applies both to your private institutions and your public institutions. So everybody should be making sure that their policies are up to date and in keeping with that law. I do think that the tenor in Illinois, beyond just the legal, those kinds of legal pieces, is very much in line with what I would say the Biden administration is now, is now going to be supporting. Some of you will recall a couple of years ago that Governor Pritzker convened a task force, again, K-12 level, on supporting and affirming transgender and non-binary students in schools. I had the great honor of serving on that task force, and there's lots of, there was great documents that came out of that, model procedures, model policy work and really sort of a full explanation of how to think through some of these issues and how to navigate those issues with students and families in your buildings. So certainly lots of resources out there on on the guidance front, if that's helpful. In terms of what we're seeing, it's really interesting to me, and I know Kendra and Jen and I were talking about this ahead of time, which is we saw a sort of a rash of bathroom and locker room type laws and cases. And obviously, as I've mentioned, in Illinois, most of those that is sort of has been sort of settled in some ways for a while based on court and administrative hearing decisions. Now we're starting to see this sports really come to the fore, and I'm going to talk a little bit about what we're seeing in other states. But it's important to remember that we do not have a law in Illinois. Nothing has been even proposed, I don't believe, but certainly not passed, that would prohibit transgender students from participating in athletics consistent with their gender identity. And in fact, at the high school level, the Illinois, where it really comes up, I think, quite a bit in these conversations, the IHSA does have a policy on allowing transgender students to participate in that way. It's a little bit more complicated. There's some process and steps that you have to go through, but they take students through that process. So we are, again, seeing a lot of that around the country, and I'll talk about that in just a moment, but we're not seeing it in Illinois. So Illinois law remains the same on that front. Again, there's some other pieces of Illinois that come into play here. Obviously, we have sex education in schools, parents can opt out. There's all sorts of other pieces to this puzzle, but all of that remains consistent with what you all have seen and known for some years, and no big changes there. And again, one of our motivations, of course, to have this conversation is because of what's happening around the country. So Jen, I don't know if you wanted to weigh in on the Illinois front before I moved on.
Oh, no, I was just maybe going to add that same at the higher ed level. There's no prohibition in Illinois on participation based on gender identity in extracurriculars, whether in NCAA's policy has for some time allowed transgender students in a similar kind of way as IHSA, not just strictly based on identification, but based on a little further review, but allowed transgender students to participate. So really at all levels in Illinois, I guess just to confirm what Nicki said, no one in Illinois is banned from participating based on gender identity if they meet the other requirements, whether it's at the collegiate or K-12 level.
Yeah, a really important point. Thanks, Jen. So what we are seeing a lot of is change in other parts of the country, as I'm sure everybody is following. So we're seeing a number of states passing or considering laws banning transgender students at the high school and college level from participating in sports based on their gender identity. Many laws have passed already, and we're starting to see some pushback, some court activity surrounding those laws. Certainly we have a law in Idaho, and we've now had an injunction by a court. And so what we're seeing is a lot of those laws going through this process of, there's a huge fight at the state house level, or maybe not so much, and then the laws go into effect, and we're seeing court cases resulting. We are also obviously, and those of you who are sort of following the news on this, in a more minute by minute, we, in Arkansas, we saw a law that really reached into areas that we haven't seen quite as much. We're well beyond restrooms at this point. They're reaching into, banning transition-related care to transgender kids. That law was passed. It has also now been enjoined by a federal court. And so we're seeing a lot of upheaval in this area. I think of interest and note, just again, not applicable to Illinois, but it is important to note just on the front of we're seeing the federal government really back in these issues again in a way that is supportive of transgender students rather than the opposite or just being silent. We're starting to see, so DOJ is, again, they're involved in a case in West Virginia related to transgender bans. They're involved in the Arkansas case that we were just speaking of, asserting their position that these laws are unconstitutional, making arguments related to Title IX, to equal protection. So again, why this is important to us is, first of all, it's just important what's going on in the country, of course, but it's also important because their interpretation of Title IX and their interpretation of equal protection is impactful to Illinois. Again, very consistent with what we've already seen in the federal court level in this state. So it's not a change, but again, an amplification of, you got to make sure that you're doing and you're behaving, your educational institutions are behaving consistently with these positions, or else you may see the federal government, DOJ, indeed, at your doorstep. We certainly saw them involved prior, and we can anticipate that again, as Jen has, I think, gone into great detail on. So there's also been some more guidance issued. OCR and DOJ issued a fact sheet related to higher ed and K-12. So again, talking about bathrooms and sports teams and all of the things that we know are issues. So again, fact sheets putting out, again, signaling where the federal government is on these issues. So again, I think you get the point on this, but a lot of movement, a lot of activity around the country.
Yeah, the only thing I can think of, Nicki, knowing that we mostly represent Illinois institutions, is that, you know, once travel resumes, or for higher ed institutions that maybe are having competitions that are out of state, it is getting to the point where one would want to be proactive and think about where their athletes are traveling to, and what kind of restrictions or jeopardy they might be placed in given the laws of those states. So there's enough going on in this area. It's something I think a responsible administrator would want to stay on top of. You know, it's also possible at the K-12, at the high school level, at times our athletes will travel out of states for competitions that school sponsored. None of the states are, well, I don't know where your kids are going, but you should, and you should perhaps again be mindful that this is a planning factor if you're taking kids out of state.
Yeah, that's a really good point. I do want to remind everybody, if you have questions, please drop them in the Q&A and we will try to answer those as well. We do have a couple other court decisions that are on sort of a different line of litigation related to First Amendment and religious freedom, and sort of the idea of, in order to protect and to support students who are transgender, you know, then teachers need to, you know, use preferred names, preferred pronouns. And obviously we've had some teachers push back on that, saying that infringes on their rights, and we have litigation on that. So Jen or Nicki, do you want to start us off on that?
Sure, I can start with a case that is out of the higher ed realm. It's a professor who was directed to use preferred pronouns. And his case ultimately is disciplined, faced discipline for essentially not doing that, not honoring it. The facts are a little more complicated than that. Ultimately, it gets up to the Sixth Circuit, and sort of the takeaway is that the professor did state a valid action that needs to be, that process needs to continue in the court. He validly can. He doesn't get the boot right at the beginning of the litigation stage. It's although early in the litigation, the Sixth Circuit was very sympathetic, I think, in their description of his position, his legal position, which was that he has some First Amendment protection in this area, and that at least if you look at the facts most favorably to him, a line was crossed as far as the way they handled him using pronouns and his religious objections to not following the religious or the directive to use preferred pronouns. This is a Sixth Circuit federal case, so it does not directly govern those in Illinois. We're in the Seventh Circuit. However, federal circuit court decisions are nothing to be sneezed at or, you know, completely put aside, and it certainly signals how some courts could look at this. I think when I read the case, one of the main takeaways is there was quite an interactive process with this professor. It wasn't just the statement to all professors, use preferred pronouns. There was a lot of back and forth where he tried to propose solutions, and then, you know, events unraveled. So, you know, they talk about the proposed solution, such as he would just not use pronouns, or would not use pronouns and use proper names where he had an objection. I think that it also highlights, you know, whether or not this case was correctly decided, or if it gets the Supreme Court, you know, if we have a circuit split, where it will go. One interesting thing, I think, is the difference between when it crosses into the curriculum. So if there's a curriculum point being made, so the discussion is on controversial topics, you know, in politics, you know, there it would be harder for an institution to curtail what a professor said on the topic, I think. And likewise, so that's where his argument is the strongest, where it intersects with sort of what his academic point of view was. You know, he was a religion teacher. I think it would be harder for someone to make the same points he did if they were, for example, a K-12, you know, art teacher. I don't know how it's going to come up, but again, where there's a curricular tie and then there's a point of view, that seems to be one of the key things. So I would not take this case to mean do not tell your professors to use preferred pronouns. I would say the opposite. You definitely have liability risk if you misgender students, or you have faculty that are misgendering students. But I do think it raises a red flag as far as how do we interact when a professor raises a concern, and try to work out a solution that's both non-discriminatory to the student, but works with the professor, if there's a middle ground that can both not discriminate and not cross into these First Amendment issues.
Yeah, and just to highlight, because I know we've talked about this on other webinars, but the First Amendment rights of professors at the college level are very different than the First Amendment rights in K-12 institutions. So you do have to keep that in mind, which is that teachers have very limited First Amendment rights. Sometimes your contracts, your collective bargaining agreements give them a little bit of room there, but for the most part, if we're looking at how courts have interpreted First Amendment rights, really limited, if almost non-existent for K-12. They really have to teach the curriculum that the educational institution puts forward. So we're going to see a difference there as well, which is important to note. And again, as Jen said, obviously will be interesting to see if something like this comes up in the Seventh Circuit. I have a feeling that there might be a little bit of a different approach. We are also just, I know we're just a couple minutes away from the end of this webinar, but I did want to note that there are some First Amendment cases going through state courts. Again, we're not seeing any in Illinois yet, although they're, and federal courts, we're seeing one in Indiana on this front. Again, same issues where, you know, people, teachers or professors refusing to use pronouns, preferred pronouns of students, and we're seeing the cases coming out in different places. So we're keeping an eye on all of those. You know, obviously, if the Indiana case goes up, we could see a Seventh Circuit opinion on it. But for the most part, we're not seeing those cases yet in Illinois. But as always, if there are them, you all will be the first to know, and we'll be happy to post them. I know, Kendra, we just have one more minute here, and I know we did get a question in ahead of time that I thought we would try to hit, which is the applicability to all of this stuff to private and particularly religious schools. And like all good lawyer answers, what I'm going to say is it depends, right? So if you are a private institution, Title IX only applies if you receive federal funds. So if you don't receive any federal funds, you are not subject to Title IX. Within those group of schools that actually receive federal funds, Title IX, there is an exception or carve out, and I know Jen can speak to this a little bit more, but for religious institutions. In terms of state law, anti-bullying law does apply across the board, private and public to K-12. And then the Illinois human rights, it's a mixed bag. So there are some exceptions in terms of the provisions. If you are a sectarian private school versus just a private school, and some pieces of the Illinois Human Rights Act, particularly the sexual harassment provisions, apply across the board. So when in doubt, call your favorite forensic attorney.
So the only small thing I would add is because we are trying to kind of debunk what to worry about in the news and what not to worry about. There's been press recently on a case that was filed, Hunter versus Department of Education, where students, LGBTQ students, are seeking the application of Title IX to religious schools. And I guess the main thing, we as lawyers, I kind of look at that and I'm like, well, you know, the exemption for religious schools is actually in the Title IX law. And we know how quickly Congress is likely to move with the 50-50 Senate on changing the text of the statute. And it's also pretty clear in the text. This is not one of those that a court has to, you know, really extrapolate. There is a religious exemption in the text of Title IX. It just is. So challenging that in court seems challenging on, you know, on strictly just wanting the law to be different. That a court, you're going to have an uphill climb on that one. But what we found to be, you know, notable is, so the Biden administration is responsible, the Department of Justice, for defending Title IX and defending that religious exemption. And as Kendra, when we were talking about this, they're basically tripping all over themselves, trying to both, you know, pursue their obvious support of LGBTQ community and wanting there to be great protection, but yet the obligation to defend the religious exemption, which again is very clearly in Title IX. So unlikely to see any great shift in the law based on the filing of this case, but it is notable for what we're seeing as far as the position that the administration will take. And so we wanted to note that as well. I think that brings us to the end. Kendra?
Yeah, I think we are at the end of our time. I want to thank everybody for joining us. Please do reach out if you have any questions. We're really looking forward to getting everybody back in school and working with you all on that. And everybody have a good afternoon.